So recently I've released a series of videos that discuss the best trust jurisdictions in the United States for 2024. We even drilled down on a few topics that make up the reasons why that these trusts are considered the best in the US. One of the things that we looked at was the best domestic asset protection trust jurisdiction in the US. But today we're going to talk about which type of domestic asset protection trust is actually the best. So let's get into it. So universally, when you're talking about a domestic asset protection trust, it means that you're talking about a self-settled irrevocable trust. That means that the person setting up the trust is setting it up for the benefit of themselves. So you just got one party, same party involved in that situation. There is this perceived legal risk with this trust. Not necessarily its legitimacy, it is a legitimate trust. Not all states have laws that offer this type of trust planning. That's why you see residents in other states setting them up in places like South Dakota and Nevada. The perceived risk is that there's this constitutional law question that has not been settled. And that is whether or not, let's say that you have a person in California who sets up a trust in South Dakota, a self-settled domestic asset protection trust in South Dakota. They move assets into it. Later, there's a personal creditor claim against that person. They don't really have any assets to settle that personal creditor claim, and the creditor finds out that they're a beneficiary of this trust in South Dakota. That creditor then tries to bring a claim against that trust in South Dakota, which the person who set it up is the beneficiary of. Now, there's this thing called the full faith and credit clause within the United States Constitution that says that states are going to give or should give full faith and credit. They should honor any judgments or laws from other states. So in theory, a creditor from California could enforce a claim against someone in South Dakota. However, South Dakota law says that it will not honor a judgment against from a foreign court, whether it's a domestic foreign court or a foreign court abroad, will not honor that foreign court's judgment against the beneficiary, a personal creditor claim against the beneficiary of a trust. Now, the issue is, well, why not? And because of this full faith and credit clause that we have, a lot of people think it should be honored, but we've actually never seen it honored. We have no court cases that say that it's actually been enforced. But there's still this concern that it could go up to the U.S. Supreme Court and be decided there. We don't know how it would be decided because it's never been brought before the U.S. Supreme Court. So some attorneys, some practitioners will say, hey, we don't know how this will be resolved, so we're not really comfortable with it. So ultimately, that's a decision that a client has to make. But we do know over decades, multiple decades, it's never been brought before the U.S. Supreme Court. Therefore, it has a good track record of being a solid way to deter personal creditors against you. But with this perceived risk out there, the question arises, is there a better solution to this? And the answer is yes. There's what's called a hybrid domestic asset protection trust. So a hybrid domestic asset protection trust is actually a third-party settled irrevocable trust. That means that one person is setting it up for the benefit of someone else. So third party, different parties are setting it up for the one party setting up for the benefit of someone else. So that's been resolved, and that's why this is a better vehicle. There isn't this issue of whether or not you can force a claim from a foreign court into the other court. So what is this domestic asset protection, this hybrid domestic asset protection trust? So it's third party. So let's just say client sets it up for benefit of their spouse and their children. So they move assets, their own assets, into that trust. The idea is that if they ever need to benefit from those assets, then the spouse or the children could share those assets back with the person who set it up, the client. There is this concern, though, what happens if that spouse passes away, or what happens if there's a divorce, or what happens if those children die? And so there is a solution to that, but I've only seen this played out in South Dakota and Nevada. I've done this type of planning in South Dakota before. So because of the really flexible trust laws that exist in South Dakota and Nevada, you could actually name what's called a trust protector of the trust, and that trust protector is there for purposes of providing flexibility. So they can assign assets, they can create sub-trusts, they can change provisions of an irrevocable trust. So there's a lot of flexibility that's built in. So you name a person as a trust protector of this hybrid domestic asset protection trust, and if that person who set up that trust ever needs to become the beneficiary of the trust, we can actually work that out. So we originally set it up as a third-party settled trust, but we have the flexibility to actually then later change the third-party settled trust to a first-party settled trust. So the trust protector can create a sub-trust from that third-party settled trust and then assign assets, the assets that the client moved into the trust, assign those assets to that sub-trust. They can move as many or as few of those assets to that sub-trust for the benefit of the client, the person who set up the trust, as they want. So it could continue to be a hybrid domestic asset protection trust, a third-party trust, and benefit a spouse or kids, and then you could carve out a little bit that client might need, or you could take all of the assets and move it to that sub-trust. And because of the third party, because of how the third party settled asset or third party irrevocable trust has been settled, there's less concern about the legitimacy of that. So there's this backdoor exit that's involved with the third party hybrid DAPT domestic asset protection trust that a lot of people really like. So there could be some estate tax planning that goes into that as well. But just know that, if you are fearful of the constitutional risk involved with a self-settled domestic asset protection trust, you do have other options. So explore those as well. And in fact, I shouldn't say probably because we don't know, but if you do like another option, it is a very viable and legitimate option that should be explored, and you figure out which one makes the most sense for you.